Supplementary cause list. Item number 1, pronouncement of judgment.
On consideration of the totality of the facts and circumstances of the case, especially in the point that is well defined, as given the chart which has been reproduced in the judgment of a single judge, reflecting the fact that the post of second IC is a Group A post, Governor Assam Rifles' own recruitment or selection procedure, there is no infirmity in the order of the learned single judge, and according to an appeal beyond merits dismissed.
Any mention? Daily list, item number 1.
May it please your lordship.
Oh.
MECL, my lord, is in appeal against the order of learned single judge, my lord.
1 second, let the file come to.
I'm sorry.
Yes.
MECL, my lord, is in appeal against the order of learned single judge, my lord. The learned single judge, by the impugned judgment and order, held that the temporary workers or contractual workers are entitled to minimum pay of a scale plus dearness allowance, which is admissible and payable to those employees who are working against the sanctioned post, my lord. On the ground that they are entitled to receive this amount on the basis of equal pay for equal work, my lord. The principal and the if I can show, my lord, the list of the employees who are going to get the benefit of this judgment, my lord. My submission, my lord, is that the learned single judge has wrongly applied the principle of equal pay for equal work in this case, because there are certain parameters which have been laid down by the Honorable Supreme Court, my lord, for applying the principles, and those principles have not been followed. My lord, if I can take your lordship to the relevant part of the impugned judgment.
Yes.
Paragraph 22 at page 43, my lord.
Page 43.
Yes, my lord.
Yes.
My submissions have been recorded, my lord. Kindly see my submissions.
Yes.
Paragraph 19. The respondent MCIL would, however, contend that the claim, page 41, paragraph 19, my lord,
Yes,
the lordship. The respondent MECL would, however, contend that claim for equal pay for equal work would exist only when there is a wholesale identity between the holders of two posts, as was held in the case of Steel Authority of India versus Divyendu Bhattacharya, and further that even if the designation of the job is same, difference in educational or technical qualification as observed by this case in the state of Haryana versus Jasmeet Singh has also to be taken into account. Reliance has also been placed in the case of Indian Navy versus so-and-so, and particularly paragraph so-and-so. This 20 minutes, said respondent has further emphasized that the point that equation of post and determination of pay scale is the primary function of the executive and not of judiciary. Such function requiring consideration of a host of factors such as qualification, as the method of recruitment, nature of duties, and courts would generally not enter upon the task of job evaluation, which is generally left to the expert body like pay commission. These provisions are present in the judgment so-and-so. 21 below, on consideration of the proposition propounded by respondent as above, where stress is laid on the aspect of equation of post and determination of pay scale thereof, which requires proper classification, best left to be done by expert body or committee. This court is made aware that case of union is not for equation of post or determination of pay scale connected therefore. They are already exist in same category. My lord, this finding, my lord, is in my humble submission is without any basis. There is no material, my lord. Simply the name of the post is Mali, and there is a Mali post in the MECL also, my lord. Now kindly see my judgments, my lord, have been distinguished on this ground that those are not relevant, my lord. I wish to place the entire judgments which are relevant, my lord, I wish to hand over the entire compilation, and in my humble submission, those judgments are relevant. If you also will see the finding on that point that the judgments are not relevant, my lord, which the Honorable Learned Single Judge said, paragraph 43, line 2, my lord, page 43, line 2. The authorities cited by respondent MECL are therefore found to be not relevant to the case in hand, my lord. And in my humble submission, those judgments are relevant. If your lordship permit me, I will circulate the compilation of the judgments, and your lordship may hear it physically on 20th or 21st, subject to your lordship's convenience.
Yeah, Mr. Yubin,
Yes, my lord.
is admitted.
Has come for the admission hearing, my lord.
it has to be admitted.
Whatever judgment that they have relied, Jasmeer Singh, has been all set aside by the popular judgment of Jagjit Singh, my lord.
We will give you ample opportunity
Yes,
to
my
make
lord.
your submission. Only that now it's come for admission. Yes, sir.
Yes, this for the admission only, my
Yes,
lord.
anything to say to object to submission? Anything, or we let it be heard?
Let it be heard on law, my lord.
Heard, Mr. A. Kumar. You appear as Advocate General or as a senior counsel?
As a senior advocate in this, my lord, MECL is there. But the state is also party, so therefore, my lord,
Okay,
let
then
it
let's
be
club it
like
together.
advocate general.
It's become a state versus a state.
Advocate General on behalf of the appellant assisted by MSR Kolni. Mr. P. Obin is present on behalf of all the respondents.
The respondent
There's only one
association.
respondent? No, your lord. One second. Just let me get it. Yes. Mr. Yubin is present. There is a counsel present on behalf of respondent number 1, and respondent number 2 represented today by Mr. Andy Shulai, London AAG. The Paradise appeal has been directed against judgment and order dated
15 July 24.
15/7/2024, passed in WBC number 133 of 2021. On hearing Learned Advocate General on the points that have come up for consideration. This appeal is admitted for final hearing. Yes.
My lord.
Listed on when?
After 2 weeks, your lordship, or 3 weeks, my lord, physically I will place
After 3
everything.
weeks for physical hearing.
Obliged.
Item number 2.
Item number 2, same order?
No, my lord. Just item number 1.
It was so progressive.
This matter, my lord would like to take up the matter. Mr. Pillang was there.
Who's Mr. Pillang?
Pillang Nongbre, my lord.
Oh,
So he was arguing for the private respondent at this point of time.
why are you objecting?
No, I'm not objecting. I'm just apprising this honorable court. I have no objection, my lord.
Yes.
My
He
lords,
was there further. Let's see he was appearing
For
further.
the private respondent. It's a Nokma dispute, my lord.
Let that go.
may it please your lordships. Lordships, there's a delay of 1 day in institution of this appeal, lordship.
Yeah, objection to 1 day delay.
My lord. But notice has to go, my lord. Private respondent is there. My lord.
Lordship.
My lord, but, my lord. I have no objection, my lord, but the private respondent may have.
Doesn't matter. Yes, we'll limit it. Yes, where's the case?
My lords,
They can, whoever respondent can engage in the council. What is there?
If in case they approach again the same counsel, my lord, only for that I have apprised this
They will
honorable.
be told that it
My,
doesn't
I have no objection, my lord. To that effect, I have no objection.
Your objection.
lordships.
Your objection if this bench takes up this matter.
No,
Because
lordship.
Mr. D has said that Mr. P. Nongbre, he
No,
doesn't
lordships.
appear in my court like he was a counsel for the private respondent at that relevant point of time. Or Mr. Nongpure appeared.
Sure, I want to inform this court that Mr. Nongbre had appeared.
Yes, no, that's already been informed. He'll be appearing also in the appeal.
He'll be appearing also in the appeal.
Then the place is for any other bench without.
Obliged, lordships.
Item number 3.
matter, my lord, I was directed to file a supplementary affidavit, my lord, in a connected matter. Item number 4, my lord. So I'm filing it, my lord. I've served in a copy, so I'll be filing it today.
3 and 4.
What is that, Mr. Siddiq? Supplementary affidavit?
Not in this matter, my lord. A connected matter.
Case, my lord, he has filed a supplementary affidavit just now. I received
What
it, my lord.
regarding?
Regarding my lord, the validity of the Karo Hills District Council and the Regulation 1954 is under challenge. And he is allowed to file a supplementary affidavit. He will serve me a copy. Matter may come up after 10 days or 2 weeks.
Mr. Siddiqui, you give Mr. Siddiqui, it's relevant for this case also.
No, it's
You
same-
please
same
give him a copy also at least.
We'll serve them.
Mr. Moomin,
Yes,
you
yes,
collect
sir.
a copy also.
Yes, sir.
Because otherwise we can't have a half-hearted kind of
Yes,
hearing.
yes.
Yes, on the prayer of on the prayer of Mr. SDL Counsel for GHDC, lists these matters after 1 week, as he has submitted that an additional affidavit has been filed on behalf of the Garhus Around Council.
With a liberty to me to file a short adjournment.
In the item number 4,
Yes, respondents will write in item number 4. Number 4, you could record same
connected
thing.
with 3.
Record same thing allowed. And the first one only time. Second one record that Mr. Charesu Pressphone is allowed to file the joint evidence. Then it lists after 2 weeks. Then. Just after 2 weeks.
Item number 5.
May it please your lordships.
Yes.
Lordships, I'm entering appearance on behalf of the District Council Lordship. We have been engaged as special counsel in this matter.
This is what's the matter about
Challenging to the amendment of the District Council Act, my lord.
amendment which act?
My lord. Amendment of the, my lord, the KGTC, CM Chiptipuri, CM and electors of
Which one?
Hima Mahara.
Mahara.
My lord, page number
You've been
41.
engaged, Mr. Paul been engaged.
Lordship.
Copy of this council.
Lordship, as special counsel.
Yes, MS De Cruz today has apprised the court that a senior Mr. K. Paul, senior advocate, the senior Mr. K. Paul has been engaged as special counsel to conduct the instant matter on behalf of the respondents number 3 to 7. How much time you want?
Lordship, 2 weeks.
He prays the matter of 2 weeks. Praise aloud. Yes, after 2 weeks, yes.
Obliged, Lordships.
Sorry, Your Honor. Yes.
Any mention?
Yes.
Yeah, please, Your Lordship. I beg to mention item number 21, Lordship. That this matter must become after 2 weeks, Lordship.
Why?
Due to personal difficulties, Lordship.
Personal difficulty, it
Yes,
becomes very personally, becomes difficult for me personally to give a time like this all the time. So, Tomani Coach,
No,
Number
Lordship.
21, Your
21,
Lordship.
Lordship.
no urgency
No, Lordship.
after 3 weeks then. Yes.
Obliged, Your Lordship.
Similar prayer, Lordship. Item number 23, Lordship.
No urgency,
Not Lordship.
3 weeks, yes. You take time, we'll give you lots of time now.
Highly blessed, Lordship.
Your Lordship, I beg to mention item number 21 on behalf of conducting counsel, Mr. M.A. Latmon.
21 is already mentioned, no?
I apologize, Your Lordship. 27.
Salchira,
I'm for the petitioner, my lord. Kindly have it next week, my lord. There's some urgency in this matter.
regarding that, 1 week is.
But the Dorbar does not permit construction.
Obliged, Your
Obliged.
Lordship.
Yes. But I thought there was some compromise.
That failed.
Yeah, please, Your Lordship, I beg to mention item number 29.
On behalf of you are?
Respondent number
Respondent.
6. Yes.
Who's for the petitioner? You've taken consent?
Yes, sir.
Where's the petitioner? He's with you?
They are here.
Yes.
Yes, Your Lordship.
You objecting?
2 weeks.
Your Lordship, actually there's some urgency in this matter.
Then let it be called out, please. Wait for it, it'll be
Your
called
Lordship.
The conducting counsel is not well, Your Honor. Your Lordship.
Who was the other lawyers in the
I am the respondent number 5, my lord.
what's the matter about?
Your Lordship, this is pertaining to non-issuance of NOC to me, Your Lordship, by the headman.
Regarding?
Regarding the sale of my landed property, Your Lordship.
I am the
You're the headman.
I am the headman.
Why not issue NOC?
My lord, I have 5 small affidavits in that, my lord, where I say that because MITTC also is claiming the land, my lord, and therefore we have requested him to produce the original sale deed.
Who has claimed land also? MIDC?
MITC, my lord.
Yeah, from MIDC?
No,
sir,
MITC has
I'm
not
the
been made
lender.
a party here, my lord. And the title suit also is going on against some other villagers, my lord.
Who's leading you in the arguments?
Miss Piriatam.
Who?
Miss Piriatam.
Who's Ms. Piratam? Anyway, we will have it next week, yes.
Next week.
Monday.
Obliged, Lordship.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 28. I pray that the matter come up after 2 weeks.
We are with which respondent? With Mr. Debnath?
Lordship, I was also informed by Mr. Devnath that he is awaiting instruction because earlier council.
What is this 28?
Yes, 28 year.
That scheme that stopped in Nehu?
Yes, Your Lordship.
Yes.
Nehu? Or where is it?
It is Bisney building last time. Earlier it was in Bisney building, but it was non-existent.
Okay, 1 week, yes.
Much.
1 week, yes.
Yes, Lordship.
Yes.
Please, Lordship. Lordship, I beg to mention item number 31. Lordship, I pray if this matter may be taken after 2 weeks, my lord.
Why keep on taking time? Some urgency is there?
No, Lordship.
No urgency? You sure?
Yes.
Then after 3 weeks, yes.
Before the state respondents, Your Lordship.
Highly obliged.
Obliged.
Your Lordship, I beg to mention item number 26.
Yes. Yeah, who's the petitioner?
I am
Yes,
here,
Mr.
Lordship.
Noksa. Any objection?
No objection, Lordship.
You're thinking for a long time before seeing no objection. So you have some little objection, that means.
No, because I think the council, district council is still sick, so that's why.
Not about the case, any urgency or not?
Not so much urgency.
And 2 weeks, yes.
Right,
Obliged.
Lordship, I beg to mention item number 22
On behalf of whom?
on behalf of petitioner.
A for the district council.
Yes. No. No. Your
Happy
objection.
for respondent 4 to 8.
Your
No
objection. No. You also no.
Cancellation of patta.
No. Any urgency? Okay. 3 weeks. Yes. 22. Right.
May you please, Your Lordship, I beg to mention item 20.
No objection, Lordship.
After how long?
After 2 weeks, Your Lordship.
No urgency?
No, Lordship.
Okay, 2 weeks, yes.
How do you pledge?
Lordship, on the request of both the council, Lordship, I beg to mention item number 25, Lordship. It's a joint request.
It's a joint request, Lordship.
No urgency?
No agency, this is regarding
4 weeks,
financial
yes.
benefits.
Much obliged, Lordship.
No point listing the time to be asked all the time.
But
Yes.
I beg to mention item number 32.
32?
Yes, madam.
Yeah, for the petitioner?
Yes, madam.
Any urgency?
No.
No urgency? Yes, just after 4 weeks, yes.
Obliged.
The request was also 4 weeks, yes.
Supplementary list, item number 1.
What is this? CRP. Yes, Mr. Khan.
Please, Your Lordship. Lordship, the petitioners herein were plaintiff number 1 and 6 in title suit.
The
One of
petitioner is plaintiff number 1.
1 and 6 in title suit number 1 of 2021. So, Lordship, they had filed an application under Order 23.
Who had filed?
The petitioner herein, as plaintiff 1 and 6 had filed a petition before the trial court under Order 23 for withdrawal, partly withdrawing the suit for the reason that they had compromised and settled the matter with the defendant.
With which defendant?
Defendant number 1, respondent number 1.
Okay.
So, Your Lordship, there is a provision under Order 23 which allows such thing to happen. Now, Your Lordship, if we just come to impugn order, Your Lordship, which is page 88.
One second.
And for the present page 88, Your Lordship, 29/5/2023.
29/5?
2023.
Now you're coming now 23.
Lordship, this is a revision. I'm aware of it, Your Lordship. There's been slight delay on that. But
what did slight delay? When was the order passed?
29th May 2023, Your Lordship, yes.
Mr. Khan,
Lordship,
how old is...
Lordship, I'm aware of it, yes. But Lordship, very important, slightly important issue of law is involved, Lordship. If I just come to page 91, the relevant part, Your Lordship. Just this. Lordship, in that context.
May 23.
Lordship, very small, important issue of law. If I can satisfy Your Lordship, then maybe Lordship may be kind enough. Lordship, page 91,
yes.
Last paragraph, in that context.
Yes.
In this context, it is transpired that the plaintiff number 1 and plaintiff number 6 jointly file instant suit with plaintiff number 2, 3, 4 and 5 for declaration right and interest in the entire suit line in question, and not just for portion of the suit property in favor of said plaintiff's petitioner. In view thereof, with the right to sue is vested jointly in all the plaintiff, this court is barred from permitting withdrawal, abandonment of the plaintiff number 1 and plaintiff number 6, petition number 67 and 69 respectively, in the absence of consent of co-plaintiffs 2, 3, 4, 5 at this stage of trial, as permission of the same will materially prejudice the co-plaintiff.
Now what happened after that?
Lordship,
More than a year's passed.
Lordship, for a moment, I'll just take to Your Lordship to Order 23.
Now what happened after that? That's 6 on 4/7. What happened?
Lordship, after
What happened to the suit?
the suit is proceeding, Your Lordship.
Where is it proceeding? Where is it stopped?
It is still in the stage of evidence, Your Lordship. No, Lordship, will kindly appreciate one thing. If I take Your Lordship to Order 23, Rule 1.5, just for a moment. So Order 23, Rule 1, Subclause 5. Nothing in this rule shall be deemed to authorize the court to permit one of the several plaintiffs to abandon a suit or part of the claim under sub-rule so-and-so or to withdraw under so-and-so any suit or part of claim without the consent of other plaintiffs. Now, Lordship, Order 23, Rule 1, Subclause 1, 2, 3, 4, 5 contemplates a situation where a parties file petition before the court. So, consent of other plaintiffs is mandatory, Your Lordship. Now, my case, Your Lordship, will kindly see page 58. Is the withdrawal is based on an agreement.
No, where's the consent of the plaintiffs?
No, Lordship,
No,
Lordship, it's not there. It's not there. Lordship, kindly see.
You can't abandon a part of the suit unless the other plaintiffs agree.
Lordship, I'm aware of it.
Then?
Page 58, Lordship, kindly see this deed of agreement.
Yes.
So this deed of agreement was part of my petition for withdrawal, which is at
When was the suit instituted? It is 2021.
Lordship, yes.
Then the deed agreements 2019.
2019,
Yeah.
there was a checkered history, Lordship, could not be enforced. And then when the title suit was filed, the parties decided to resolve. Lordship, by relying on this, I'm just coming to.
The very fact that, we can cross the threshold for admission also is debatable, Mr. Khan.
Lordship, kindly just allow me to just complete this part of it.
Of course, I will complete, but then you have to address the other issues that the court has. Yes.
The finding, Lordship, the finding of the trial court was there was no consent of plaintiff, hence it was rejected.
Yes.
My relying on this deed of agreement, Your Lordship, I have mentioned specifically in my petition, which is at page 80.
Page
80, para 9. The starting is page 79, Your Lordship, the petition. Yeah. For the present purpose, Your Lordship, this is a withdrawal application. So, Lordship, you kindly see page para 9. It may be mentioned here that one of the petitioners, so-and-so, along with the family members, has entered into deed of agreement with so-and-so, an agreement dated 26/11/2009. In the said agreement, the petitioner, Sri so-and-so, along with so-and-so, with two family members, agreed to withdraw themselves.
Mr. Khan, if you're saying that this agreements arrived at previously with the other plaintiffs also were in the same understanding, correct?
They were not. No, Lordship, it was not. It was not affected. This agreement was part of the withdrawal petition. My only limited submission, Your Lordship, is this Order 23, Rule 1 will not be applicable. Rule 3. My withdrawal application is under Order 23. Now, Lordship, I will just take to Your Lordship to Rule 3. I read out Rule 1, 5. The learned trial court has misdirected itself by passing an order under 5. But since there is an agreement, the moment an application is filed with an agreement, then the rigor of 3 comes in, Your Lordship. If I may just read out, Your Lordship, compromise of a suit. We do not find the word agreement in 1. Order 23, Rule 1, 2, 3, 4, 5. But in 3, where it is provided to the satisfaction of the court that the suit has been exhausted wholly or in part by any lawful agreement. 3, Your Lordship. Order 23, Rule 3. Where it is proved to the satisfaction of the court. The first requirement for the court is it has to be satisfied that the suit has been exhausted wholly or in part by a lawful agreement. My emphasis is a lawful agreement. Now, lawful agreement, we don't find lawful agreement under Order 1, Order 23, Rule 1, Subclause 1, 2, 3, 4, 5. So, Order 23, Rule 1, 2, 3, 4, 5 will not be applicable. The consent of plaintiff will not be applicable, Your Lordship. If there is a lawful agreement, then the trial court has to direct itself to Order 23, Rule 3.
See, the thing is that adjusted partly, yes, with you.
Lordship.
But what about the other plaintiffs?
Lordship.
That is the question.
Lordship,
see, the other question, they are not on the same page. Then you can't compromise for the suit yourself and one defendant.
Lordship, I'm coming to that.
If the agreement speaks like, okay, fine, then again for a portion of the suit land, there's some agreement, well, okay, fine. For one part, you can abandon the claim.
That is exactly what the agreement.
The agreement will say that.
Lordship, the agreement has said this.
You can't say that now, like, you abandon this part and I withdraw without the other plaintiffs.
Lordship, if I may submit on facts, the claim of other plaintiffs are fully kept intact in para 9. It is not the case I'm compromising everything. Lordship, only limited law issues involved, Your Lordship. The court has to be satisfied.
All, Mr. Khan, like we might be making new law then.
No, Lordship. Order.
If we are bound by Order 23.
Lordship, there is a fine distinction between Order 23, Rule 1 and Rule 3. Under Rule 1, consent of plaintiff is mandatory. Lordship, I may just take you again. Please. Order 23, Rule 1(5). Just to be very brief, Your Lordship, under 23, Rule 1 does not talk about a lawful agreement. The consent of parties will be required only if there is no agreement.
Have the parties signed the agreement, all of them?
No.
Then?
No, Lordship, no. We have made them parties here, Lordship.
Have they signed the agreement?
But
Did they sign the 2019 agreement?
Lordship, the other parties have not signed. Petitioner 1 and 6 have signed with defendant number 1 only for his claim in the suit.
I'm sorry, Mr. Khan. See, if there's an agreement, even if it affects party A and party B, okay, plaintiff A, okay, and defendant X, then there's X, Y, Z, the other defendants are there, then plaintiffs are A, B, C, D, right? Suppose plaintiff A comes understanding with defendant X that fine, like, for
a part of his share.
Whatever concerns two of us, we will settle it. Fine. What about the other people? That the agreement must be saying that this plaintiff A has entered into X, and if they put the signatures in that agreement, then well and good, then 3 will come into play. But if the signature is not there, an instrument, that means how does it come to play?
For a very limited prayer, the trial court has rejected my petition on.
The trial court has to say.
Your
You're appearing for whom, Mr. Day?
I'm appearing for district council. They have made district council also party, settlement officer and the secretary.
You should notice, but the thing is that even the mentality of your application also.
Lordship, if you read the page 91, Lordship, the last part, Lordship, kindly only I have just got a very small window to argue, Lordship, and I'm praying only for remand.
One window, you got a small skylight to argue for. Yes.
Lordship, will kindly see the operation part of para 91, Lordship.
Yes. In that context.
Your Lordship, in this context, it transpires that plaintiff number 1 and 6 have jointly filed instance suit with plaintiff number so and so for declaration right interest of the entire suit lying in question and not just for portion of the suit property in favor of the said plaintiff petitioner. In view, therefore, where the right to sue is vested jointly in all the plaintiffs, this court is barred from permitting withdrawal abandonment of plaintiff number 1 and 6 petition number so and so in the absence of consent of plaintiffs 2, 3, 4, 5 at this stage of the trial, as the permission of the same will materially prejudice the co-plaintiff. Lordship, consent of co-plaintiffs will be material.
When there's no application, you say?
When there is no lawful agreement.
But with your agreement, it doesn't have the signatures?
No, Lordship will just come to 3. When it is proved to the satisfaction of the court, the first requirement, when this petition was moved, the court had to resort to 3 and say whether the court is satisfied the agreement is lawful or not. There is no finding. Lordship, there is no finding by that. Court has resorted to Order 23, Rule 5, which is not applicable. I would have no grievances if court would have taken its route to 3 and rejected. And what is the status of lawful agreement now, Lordship? That court has totally overlooked. My only limited...
Have you argued that?
Lordship, yes.
Where have you argued that?
No, Lordship, we have not argued that.
Then?
Lordship, we have not argued that.
We didn't argue that point.
Lordship, we have not argued. We have just argued...
How court to render a finding on a point has not been raised?
Lordship, we have argued only on Order 23, but Order 23, Rule 1, we have not argued on that. Prima facie, Lordship, when the moment a lawful agreement is...
Mr. Khan, you're propounding an argument which, if it's not even an issue for a trial court, how do you extend a finding and you say the finding is not there?
Lordship, the finding was on Order 23, Rule 1(5). The moment a lawful agreement comes in, Lordship,
where is it in your arguments that you raised it before the trial court that an agreement is there? That that with
Lordship, para 9 of my petition, Lordship.
No, not petition. Where is reflected?
Oral argument, Lordship, is not reflected. But my foundation of argument is in para 9 of my petition.
Dispose of this matter here only. You take your chances.
Lordship, kindly, we just want to remand back the matter and consider as per Order 23, Rule 3. Only a limited prayer.
It was never made there. How can you raise an issue now here which was never raised?
Lordship, my pleading foundation...
You're fighting a tough case, Mr. Khan, because as a senior counsel, you've been briefed. Mr. Hassan's a culprit anyway.
Lordship, only thing is at this stage, notice may be issued, Lordship. Kindly. Lordship, we kindly understand the finer point is this. Oh, yes,
That's why, because
23.
court is trying to understand the finer point. That's
The
why
finer
it's
point
not, it's not ready to give you relief. because
Lordship, oral argument was not
it
forwarded.
goes against,
Lordship, oral argument was not
Where's
forwarded.
where's the application then?
Lordship, I read out the application, which is a
Where is it?
I have
Have you
mentioned.
annexed
Lordship, the application is at page 79.
Okay.
I read out para 9, Lordship. My pleadings is there that there's a lawful agreement. Page 79, Lordship. Page 80, relevant para 9. There's a specific pleading about the lawful agreement. Now it is duty bound for the court to satisfy first under 3. No, that has not been done.
K. Khanna Senior Counsel on assisted by so-and-so on behalf of the petitioner issue notice. Mr. SD is present on behalf of the respondents number 2 and 3. Such no further notice on these two parties. Notices to issue to the remaining respondents 1, 4 to 8, but I said 80 within 3 days. Stop. This application has been preferred against an order dated
29/5/2023.
And such other issues that will arise with regard to the delay will also be addressed by the court on appearance of the parties.
Lordship, we're not praising for stay, but subject to outcome, because if you don't know when the
I know, but there's a anyway, yes.
Much obliged.
This matter has to be closed down, my lord. Item number 2. We have issued the check yesterday. They are not going and collecting it, my lord. On 12th,
You're collecting it. Why, Mr. Sheikh?
On 12th, it was issued, my lord.
My lord,
This matter can be closed down, my lord, with this.
I'll take instruction, Lordship.
The check
Because
is-
my
check
lord
is
will
lying
kindly,
there, my lord.
my lord will kindly see
Your
the.
name is Shariful Islam Mullah.
Yes, my lord will kindly see the order, Lordship.
20,76,698 only. Then
My lord will kindly see the order, Lordship. Order. My lordship, page 8, Lordship.
yes.
My lord, para 3, Lordship. Accordingly, it is directed that the entire amount should be settled within 8 months from the date of the receipt of the copy of this order. It is expected that the substantial amount should be accorded as a funds installment to enable the petitioner to tide over his financial difficulties. Interest as applicable at the rate of 6% will be given to the petitioner. Lordship, my principal amount is rupees, Lordship, 19 lakhs, 59,000, Lordship. Now they have issued a check of rupees 20 lakhs.
Whatever may be the calculation, my lord, they can go and hesitate there, my lord.
See,
Fresh course of action.
when contempt is what, Mr. Sheikh, when there's willful disobedience, or they go against the orders of the court which are passed. If orders have been passed or checks have been issued, which is, whatever it is to the understanding compliance, then that doesn't constitute contempt. And contempt not between the petitioner and the court.
True, right.
It's a check, a copy of a check dated
12/11/2024
produced for this court, showing the fact that an amount of rupees
20 lakhs
76,698 only has been made in favor of the petitioner. As it is seen that there is no willful violation order to this court, this contempt flows at this stage.
Then liberty, Lordship, so far as that.
Liberty and contempt, liberty and fresh cause of action.
Item number 3.
Plus, this is one more of those nectar matters. My lords have already issued notice in the other matters yesterday.
State Policy Council issue notice returnable in 3 weeks. Steps are taken by State AD within 3 days. List on so and size.
Item number 4.
This matter pertains to the cancellation of the trading license by the district council.
We've served copies.
We've served
Mr.
copies.
Panti.
We've served copies. This seems to be a case of miscommunication, Mills, because the application, our case is my application is pending with them.
Your opinion, Mr. Council?
for state lordship. Lordship, can this matter identified for lordship? I don't know whether this matter has been endorsed to whom lordship. I just find out.
State doesn't have much to.
They received it there.
Notice. This copy's been served.
It has been served in the office. It's not been sent to me.
If we just take down Mr. Capewell and counsel with petitioner, issue notice. Mr. Karwan Lang is present on behalf of the respondent number 1. So no further notice. Number 1, it is reported that notice has been served in the office of District Council respondents 2, 3, 4, and 5 yesterday. This is matter on Monday. Yes.
In addition to this, my lords, I informally I'll just apply.
Item number 5.
Please, Lordship, I request the Lordship if this matter may be taken up at the end of the vote, Lordship.
What are you asking for, Mr. Pathak?
At this there's a notice only. This is the second round of litigation where my application, I'm already posted and I have already joined, but my application, my lord, was rejected by saying that there is no vacancy. Whereas on the date of application, there were vacancies, and subsequently, my lord, they have filled it up by some other individuals.
Okay,
so
yes, I understand. Heard Mr. B. Pathak and counsel for the petitioner. Issue notice. MSR Gurung Vice, Dr. N. Bozikadi is present, except on behalf of all the respondents. No further right list after 3 weeks for instructions are affidavit. Yes.
6.
Last leg posting, right? I saw last leg posting. Okay.
Item number 6.
My lord, here the petitioner husband was working under the office of the respondent, lordship. And while in service, he died on 4th of October 2019, lordship. Now, lordship, so far as the other benefit is concerned, the petitioner's mother-in-law, brother-in-law and the sister-in-law has filed a succession certificate, lordship. And in the succession certificate, I have filed the counterclaim, lordship, and the matter is pending, lordship. Now, the department, I am again asking for submission of the succession certificate to release the pension, family pension, lordship. Here, lordship, the family pension is governed by the pension rules, lordship.
Yes.
Assuming that tomorrow, that if the succession case gone in favor of the mother-in-law and the brother-in-law and the sister-in-law of the petitioner, lordship, still they are not entitled to claim the pension, lordship. That pension, the family pension will be governed and decided by the family pension rule, lordship. Lordship will come, kindly come to pace, lordship.
Will family pension be part of terminal benefits?
My lord, family pension is a
part of terminal benefits?
No, lordship. It is not an estate of the deceased, lordship. Does not form the part of the estate of the deceased. It will
part of the terminal benefits.
Yes, lordship.
DCRG, leave encashment.
Yes, so far as DCRG, leave encashment, other benefits that we are hesitating, lordship, before the succession court, lordship.
But
now,
but why is the succession court? They don't family pension also is been claimed by them.
No, lordship.
No,
I have enclosed the plain, lordship. They have not claimed anything. Only that is at pace, lordship will come.
Page.
Page 22, lordship.
GP leave salary. Okay, yes. Proposed pension, see, they've claimed.
That is the chart given by the lordship. Will kindly see. That is the thing given by the office, lordship. That is a page 18, lordship. That is given to me in order to obtain the succession certificate, lordship.
Okay.
So now, lordship will kindly see page 7, which I have copied the rule, lordship. That amended rule 2010, lordship.
First claim is whom?
Wife, lordship. Wife.
You are legally married?
I am legally married, lordship. Then the mother is the second category relative, lordship. Yes. Then in the event the first category relative cease to become eligible to obtain to get the family pension, then the claim will go to the second category relative, lordship.
Yes.
Now, lordship, here during the lifetime, lordship, my husband has taken some loan, lordship, and the time and again the banker also, they are issuing a notice asking to refund the amount, lordship. that I have enclosed. So at this stage, Lordship, what I am only claiming for release of the family pension also. So far as the other benefits is concerned, Lordship.
You should notice we can't order right.
Lordship.
Yes, but Mr. S.A. Sheikh, another counsel for the petitioner, issue notice MS Ilingwa is present on behalf of
1 to 4, Your Lordship.
respondents 1, 2. Where's the other side? Where your mother-in-law?
Mother-in-law, I didn't make party,
Why?
Lordship. Mother-in-law, my lord, so far as family pension, mother-in-law.
Have they given you NOC?
No, Lordship.
Then?
No, the mother-in-law, my lord, will govern by the family. My lord recently has passed an order that daughter-in-law who was more than 25 years of old and come to this court and claiming for pension, Lordship. My lordship has rejected the claim,
I don't
Lordship.
remember anything, yes.
Lordship, your mother-in-law, as per law, family
Yeah,
pension.
of course. But you should make them party at least pro forma, whatever. Yes, 1 to 4 and MS EB Pasap for 5. So those complete just after 3 weeks construction affidavit, yes.
Item number 7.
Because see, Mr. Sheikh, we don't object because first claim is the wife, and finally pension it goes to the legally wedded wife. That is the settled law.
That is
just like that. And if others, that's it. Yes.
That is why I didn't make party, Lordship.
It's a matter of peculiar circumstances that are here before your lordships. What had happened, my lords, is that I was initially appointed as a lab technician, my lords, on 6/8/1993. And my appointment is at page 10, my lords.
Yes. 93.
My lords.
Yes.
Thereafter, my lords, this particular post was sanctioned as a permanent post, my lords, that your lordships would find at page 14. It is the typed copies at page 15, my lords.
Yes.
Well, it's 2,289 posts was sanctioned, and well, it's my relevant post. Your lordships would find it at page 18, my lords.
Yes.
Now, second entry from the bottom, my lords, lab technician. Your lordships will kindly see.
Yes.
Now, thereafter, my lords, what happened is I am confirmed as against this post.
Yes.
My lords, I'll skip the ACP part. As granted an ACP in between, my lords. If your lordships kindly come to page 21, Annexure 4. My lords, this is on 24/1/2019.
Yes.
In the interest of public service, the following incumbents under the District Medical and Health Officer Hills are hereby confirmed as lab technicians with effect from the date of issuance of this order against the permanent sanction post mentioned against each post, my lords. Serial number 5, my lords, is the petitioner before your lordships. Now, I am continuing as a permanent employee, my lords. All of a sudden, in 18/3/2023, Annexure 5, my lords.
Yes. Item, serial number 69.
My
You
lords.
regularize now.
Now.
You don't regularize earlier on.
Well, lords, I am confirmed.
It's confirmed. It's there. There have been cases where confirmation is given, but regularization not done. But you will be regularized from the date of your earlier appointment. Yes.
Now, my difficulties, my lords, most of these petitioners before your lordships, my lords, are on the verge of retirement. Now, some of them have, my lords, 3/4. Only limited to that extent, my lords. We don't want any relief. We have.
Sometimes just to correct the service records, they're just appointed against sanction posts, not regularized, and then they are confirmed.
My
They're
lords.
getting confirmation before regularization. This is not the only
Well,
case.
well, it's actually
It's an aberration.
case of the cart before the horse, my lords, I think so.
Lordship, in fact, I would like to raise the maintainability of this writ petition.
No need, Mr. Shulai.
Lordship, because the order 18, which is under challenge, Lordship, this is only a consequential order, Your Lordship. There was a decision of the cabinet, and that decision was not put in challenge before Your Lordship.
The question is an aberration. They only have to correct the records.
Well, lords, it is something that would benefit the government.
Yes.
I am here to benefit the government. I am not going to get anything out of it.
Challenge the cabinet resolution.
Because there is a policy, Your Lordship, adopted by the personal department, by the government, Your Lordship, that only those people who have been appointed prior to 2007 will be entitled to regularization as well as pensionary benefit.
I think, Mr. Shulai, maybe 2 or 3 years ago, this court itself, in a similar case, had passed some orders, whereby they already confirmed But at the time when they retired, what happened was, to regularize their pension payment order, they found that they found it not regularized in service.
Lordship will have to see
and so
whether
that
the
then
director
orders
is
have passed
the
by this
competent
court that
authority
they
or not, your Lordship, to confirm. I'll have instruction, your Lordship. So far that.
No, it is not the director who's confirmed. It says it is on the orders of the competent authority, the governor of Meghalaya.
DHS is not by the DMHO.
He's just communicating that order.
Yes, you should notice, Mr. Indishulai, this was on behalf of all respondents with so no further notice required. This after 2 weeks or
3 weeks. 3 weeks, your Lordship.
Okay, 3 weeks.
7 to 11, your Lordship.
7 to 11 are similar matters. Well, it's only in item number 9. There has been an error by us, Malaj, insofar as the impugned order is concerned. There were 3 sets of impugned orders. So, Malaj, I'll file an additional affidavit just bringing the name of the petitioner on record.
9 for issues also. As Mr. K. Paul submits that there's been some small defect
in the annexure, Malaj.
With the regard to the annexures, he's permitted to bring the same on record by way of additional affidavit.
That's
obliged.
Highly obliged.
Item number 12.
Answer.
You served?
Yes. I'm appearing for respondent number 2, my lord.
Yes. Let her file her form.
My lord, here the problem will be a bad precedent will be there, my lord. The students who are attending the classes regularly, my lord.
No, but she has medical certificates.
No, my lord. She has undertaken that she will attend 75% of classes, my lord. This is the undertaking she has taken, my lord. And this is not the first time that she has taken leave for long, my lord. She has gone for leave.
But one thing, Mr. D, she's passed other semesters.
We have allowed her at that point of time also, my lord. This is a regular phenomenon, my lord.
And she clear all the semester, Your Lordship.
She may clear, my lord, but that will set a bad precedent, my lord. Whereas she has undertaken, my lord, that 75% of attendance is required. Moreover, my lord, if my lord may kindly see the medical certificate, my lord.
No, but this is
She
a
might,
general
Your
one.
Lordship, she might take undertaken, but it's health issue, Your Lordship. We can
My lord, may kindly
not say
see
anything. Your
the
Lordship.
date from which she was undergoing treatment, my lord. Page 15, my lord, Annexure 5.
Yes, Annexure 5.
Yeah, my lord. 1st of October to 6th of November, my lord, she was undergoing medical treatment, my lord.
Yes.
Under the supervision of Dr. B. Lindau, my lord. Now, my lord, prior to this, another medical certificate has been enclosed, my lord, which shows, my lord, that she was taking medicine and all, my lord. Then again, my lord, from the same doctor, my lord, again on page 13, my lord, if my lord may kindly see.
Yes.
Now, my lord, from 10/7/2024 to 23/7/2024, my lord, she was under medication, my lord.
Yes.
And she was fit, my lord, to attend. And she should have at least, my lord, informed the school or college, my lord. She has not even informed the
Only
college.
one thing now, Mr. Said, suppose they miss one semester exam, can they repeat it? They can repeat it.
They can repeat. That's not a
But,
problem.
but the thing is, Your Lordship, if she missed today, Your Lordship, then she'll have to wait for maybe 2 years, Your Lordship, because
no,
1 year, Your Lordship. She has to wait till the next 5th semester again, Your Lordship. So that is why.
Can she go to 6th semester without clearing 5th semester?
I don't think so, Your Lordship.
That I have to take.
Because the thing is like that in some
The backlog they can clear.
The backlog, but will she go to 6th semester? Can she attend 6th semester classes without clearing 5th semester?
Yes, yes.
You do that, then you repeat 5th semester.
The Your Lordship, here the petitioner, Your Lordship, despite this signal also, Your Lordship, she didn't want to. She want to pursue her studies, Your Lordship. So if
25% and prior application should have been submitted.
Yesterday, her mother herself had appeared in court. So I told the mother that,
at least, Your Lordship, let her appear in exam, Your Lordship.
There'll be a floodgate of cases because many people don't have the required number of attendance.
But at least let her consider, Your Lordship, let her appear.
It's a duty of principal as per the university regulations to forward the applications of students who want to sit for the semester exams. Exams are controlled by the responding university. So if they refuse, do you think the court can compel them to say you give a certificate, allow them? If they're saying no,
Well, Your Lordship,
the only thing is that for consideration, can it be considered? It will set a bad precedent.
And it will open a floodgate also, my lord. And moreover, my lord, they should have at least filed an application informing us, my lord, that she is undergoing medical treatment and all, my lord.
In fact, Your Lordship, she had informed
But there is nothing on
but
record to show, my lord. There is nothing on record.
Whereas the next year you said you're not written to the college once also?
No, Your
Let me file my application because of my health condition.
Your Lordship, actually, there is no copy, Your Lordship. She just submitted to the college website.
Moreover, my lord,
It's there in the college records.
No, my lord, I have no instruction. I have to take instruction. Moreover, my lord, it's only iron deficiency, my lord.
No, we're not, but doctors here to go into.
No, the disease they are showing, my lord. But we have an objection, my lord, in this petition, my lord. We may be allowed to file an affidavit also.
Then become structure.
Because Monday is an exam, Your Lordship.
Moreover, my lord, no statement has been made that they have approached the college authorities, my lord. No statement.
So for university is concerned, my lord, if they say, if the college say, my lord, I am not compelling that. If the college say she's at 75%, my lord, we have no problems.
But we cannot say 75%.
My lord, I am not saying this is between the student and the college, my lord. They will process.
We have come across one notification. That is by Nehru.
What notification is that?
What you say like this, please handle it.
Please handle it.
I'm not giving to you. If Lordship, can you see, I can
10? Where is that?
That is, has been flagged, Your Lordship. Lordship, can you see attendant that 10, Your Lordship? A student must have attended a minimum of 75% of the lecture. So, then, Your Lordship, can you see 6, Your Lordship? The school board may, on the recommendation of the department concerned, consider the decision on the request for condonation of shortage of attendance up to 5%. Condonation of any shortage more than 5% and up to 15% may be recorded by the board to the vice chancellor with full justification whose decision will be final. So, Lordship, our board has to, if it does not have that 75%,
It is up to my lord 5 to 15%.
then this has to be recommended by the board, and not the decision will be taken by the vice chancellor.
Mr. Sun, he said come instructions yesterday, he didn't produce this one.
I'm sorry.
Here
is your document.
This is a document, Your Lordship, we got from the website of the Nehru, Your Lordship.
Which year?
It's your university. This is 2002.
2000?
23.
But even then, otherwise, if your lordship will 5 to
No, this is for master's degree.
It's same,
No, it can't be same.
No,
my lord.
bachelor's is different, master's is different.
Altogether different master's.
Well, master's is different. This is master's, Mr. Shulai.
It's same, Your Lordship.
No, it can't be same, my lord. This is at the
Have a look
affiliated
at
college.
it, Mr. Sir.
Yes, my lord.
It's under a college by itself.
Specifically, I obtained instruction, my lord. They could not have misled me, my lord.
It's for masters. Masters will be different.
University, Your Lordship. This is
No, masters isn't there top masters.
Yes, my lord. This is for master's degree, my lord. We are not concerned with this. In fact, my learned additional creating unnecessary confusion here. Just downloading something, my lord, which is not relevant. Should be responsible in making submission like this. 75%, my lord, for the affiliated college also, my lord. Graduation also is there. My lord, I yesterday
because
asked.
the thing is that, see, Ms. Nyota, is entirely up to the college, your college.
Yes, the thing is,
Now,
they
with
refuse
the
the
materials
lordship.
you put here, we do not see that you put even a prayer for the college that I have 25% and this is the problem. These are the medical certificates to make up for my shortfall in attendance. That's not here also. There are only 3 medical certificates for a specific number of days. And if they condone it, you can by today you decide.
I will instruct them.
Yes, Mr. S. D. is under appearance on behalf of the
Respond number 2.
One number 2. Son number 2. That is the concern that the college the concerned college wherein the petitioner is studying. So, he submits that there has been no application whatsoever has been filed before the college authorities for condemnation for the shortfall in the attendance. Further, he submits that as an undertaking had also been given at the time of, but this is the general standard form.
At the time of admission.
At the time of admission, the student is bound to comply with the undertaking with the requirement of attendance. Next paragraph. It is noted that the writ petitioner has perhaps come before this court as a last resort in view of the fact that the fifth semester exams are scheduled for Monday, the 18th, and the last date for submission of examination form and fees is today. Today is the 14th of November. So, in these circumstances, after hearing the parties, one number 2 is directed to to consider the case of petitioner. But what time is the examination fee close? 3 o'clock?
Maybe 5, Your Lordship. Maybe 5. I'm not sure, but till 5.
Before the close of the college working hours. Yes. It is also directed that the mother or the petitioner be present in the college at that time.
Let them file a proper application, my lord, along with the medical certificate, my lord.
Yes, and to that time with whatever testimonials as necessary.
We'll take a call, my lord.
Yes. Take a call because she's a student and she even 4th semester she hardly attended, but she passed the exams and all. That means that she's not a bad student.
No,
not a bad student. It's not a question
of student, my lord. But only worry part is this, my lord. It will put a bad precedent, my lord.
No, won't put a bad precedent. If you can give the reason order because it's in your hands.
My lord, I will.
All right. What is this?
Lordship, my deceased husband had purchased a plot of land and he had made a building therein.
Had purchased a?
Land. And he had made a building therein, Lordship. Now, that building is my only source of livelihood for me and my minor daughter. During his lifetime,
He give it to you.
Lordship.
That building is in whose name?
Lordship, it is still in his name, in my deceased husband's name. He died in 2021. I am one of the wives. I am the third wife, the last wife with whom he resided. Now, Lordship, what had happened is against this building, he had mortgaged the building to take a cash credit loan facility for running his business. So against the building, he had been given a cash credit loan facility of up to 30 lakh rupees. Page 46, Lordship, is the head, Lordship. The CC mortgage account with a limit of 30 lakh rupees.
Okay.
Lordship. Now, Lordship, post his death, which happened on 6th of October 2021, I have been regularly paying the bank the loan amount on a monthly basis so that the loan does not go bad and the account does not become an NPA account. Now, Lordship, they have been regularly imposing interest upon me. Despite that, I have been paying whatever I can, Lordship. Lordship, the last deposit slip is at page 55 and the pages preceding that, starting from page 47. Lordship, see the last one.
What his account with Gribedakhar is dead, then how come he paying to the account?
Lordship.
How come he paying to the account if he's dead?
Lordship, it's a cash credit account. It's a loan account. So till the loan stands, I have been paying, and Lordship would see 30,000.
Every month.
Every month, Lordship. I am getting a rent of all 65,000 from the rented property. One half I am keeping for my survival, my daughter's survival. She's in class 9, studying in a school. And Lordship, in fact, my husband also left a car loan upon me, which was amounting to, for which I was paying an EMI of 7,000, Lordship, page 53.
53 is a car or is the
Lordship, page, the top right slip for 7,000 is for the car. And Lordship, page 76 is where I have cleared that loan.
of the car?
Car, Lordship, and the bank has given me a loan clearance certificate. Lordship, I have. Lordship, I have a good conscience, and I want to clear this existing loan. Now, Lordship, to my surprise, Annexure 70, page 73, Lordship, Annexure 7.
Yes.
Lordship, that is the notice of possession they have given me, saying that an outstanding of 29,21,025 rupees exists, and thereby they are taking. Lordship, when.
This is what is your name?
Lordship, my name is that is the first wife, Lordship, whom they have named.
But it's on her, not on you.
Lordship, she is one of the guarantors. She was. But
Then she issued a demand notice calling upon Srimati Jonita Mary Nongrom. Where she's here?
I have made her a part. She's a respondent. Respondent number 4. In fact, I have filed a title suit also, Lordship, with regards to this property.
No, we are servicing the loan, and why is 29 lakhs still outstanding?
Lordship, because I have been servicing 35,000 right from 21. The bank is saying that that is the interest that I am paying. But they have been taking this money from me.
If you should notice no interim orders, because
Lordship,
you're not the owner of this property.
Lordship, my husband was the owner. If Lordship, if I can have your Lordship back to the possession notice, it says right in the bottom, Lordship, we invite your attention to the provisions of subsection 8 of section 13 of the Sarfarazzi Act, which speaks about the time available to the legal heirs or guarantor to redeem the secured asset. I am a legal heir, Lordship.
Where is the marriage certificate?
Lordship, Annexure 1, page 19.
Marriage certificate?
Birth certificate of my daughter.
No, marriage certificate?
Lordship, our marriage was not a formal marriage where we registered it.
So how can you be legal heir then?
But Lordship, I am the wife. I will come to that also. If I can have your Lordship at the birth certificate once.
No, forget the birth certificate. What I'm saying is
Lordship,
the charge is created by your
page 23, Lordship,
and the claims been made against the wife of the and one of the wives of your
one of the
husband.
wife. Lordship, since he had a marriage in the church, being a Catholic, he could not have annulled that marriage. But page 23, Annexure 3, Lordship, is a recognition of me.
Page
23, Annexure 3.
By whom?
By the Darbar Shnong, Lordship, where we were residing.
Darbar Shnong. Mr. It's a day for very twisted cases, I think.
Lordship. Lordship, it clearly states that I am the wife and Yashikala Dakar is my daughter. And Lordship,
issue notice, Mr. Kera.
Lordship, tomorrow they will take 17. They'll take possession, Lordship.
Where is it written 17?
Lordship, Annexure 75. Annexure 9, page 75. Annexure 3, para 3, Lordship. We hereby give you notice of 30 days to vacate the house so that a physical possession of the aforesaid immovable property can be undertaken.
The bank? Where have you approached the bank?
Lordship.
Have you approached the bank?
Lordship, we have approached the bank.
Where's the document?
Lordship, we have not written anything, but I am paying them the money. They are taking my money.
See, if you're paying the money, if you don't want your loan to go in NPA, or you don't want them
Lordship.
to take possession, or then you always communicate with the bank.
Lordship.
It happens to umpteen number of cases.
Lordship, when she has tried to go to the branch from where the loan was taken, branch says you go to the head office. Head office says branch will look into it.
No. Where? Show me some documentation to show that I am that she is the illegal heir, that she is servicing the loan, to tell them like I'm clearing it within so and so, that it won't go NPA. NPA, that means it's locked and your interest just goes up.
Lordship, the amount that I'm depositing it online also, and I'm.
Mr. Kera, what your code you have done for the bank?
Lordship.
Show me one document to show that the bank has communicated to you, to this, what's her name, petitioner? Okay.
Sentirendra. Lordship, the minor daughter, the petitioner number 2, she is a legal heir, Lordship. She is the daughter.
Who? The legal heir?
Petitioner
number 2.
Lordship, she is the daughter. If I am the wife, I am the mother. Lordship, Annexure 1, page 19.
You approach the bank. You go to the itself.
Lordship, Lordship, some interim protection may be given. Otherwise, if I am dispossessed of the property, I'll not have any Lordship, I'll not have any income left to survive.
30 days is not given that today they'll do it. Banks are very slow, don't worry. Yes, I know that it's just a large-ditch effort you've come here. But the thing is that there are no material to show that, what is your connection to the property?
Lordship, Annexure 1...
Apart from the fact that you're servicing the account.
But Lordship, I am servicing because I am his wife.
This property is collateral and a mortgage by late husband, whatever, to secure a loan.
Lordship,
and the demands made against the guarantor, who's the fourth wife, or who's the first wife?
First wife. Now, Lordship, the second wife also has been made a party here as respondent 8. However, Lordship, I am the one who's servicing this account, and my daughter...
Sorry, Mr. Khera. Here, Mr. N. Khera, the counsel petitioner, you should notice returnable in 2 weeks. The steps to be taken by said AD upon the respondents.
1 to 8.
3 days, yes. Next paragraph, Mr. N. Khera submitted that the petitioner, who stated to be the third wife of one deceased late girl.
Lordship, 2 petitioners are there. Petitioner 1 is the wife and 2 is the daughter.
Mr. N. Khera submits that the grievance of the petitioners was stated to petitioner 1 stated to be the wife of the one deceased. What's the name? Sorry.
Late Gilbert Dakhar, Lordship.
Late Gilbert Dakhar and daughter is with the possession notice issued by the respondent number
1, respondent 2, Lordship, issued the notice.
Respondent number 2, which is to do with a cash credit loan which had been availed of by her late husband. It is submitted that the petitioner has been servicing the loan, but for reasons unknown, the bank has issued the notice dated 16/10/2024.
And 17/10, Lordship, 2 notices.
17/10/24. Next paragraph. On query from the court, Mr. Khera submits that there is no documentation to show that the petitioners have ever approached the bank itself with their problem. Accordingly, they are allowed to approach the bank with appropriate application for consideration. Yes, list up to 2 weeks. Yes.
Lordship, the operation is
See,
suspended.
we can't, Mr. Even the charge is not on. You're nowhere in the picture. You're not named anywhere.
Lordship.
If you can go to the bank and say that, otherwise the bank, they'll have their own mechanisms to, if you really can. You're not even gone once also. What the court's given you also is more than what you've given. If you won't retain this at all, your name doesn't figure anywhere. You don't have marriage, nothing.
Lordship,
a person is saying that, I'm servicing the loan of some person. And
Lordship, but my birth certificate of my daughter shows me, Lordship. We'll approach the bank immediately. Obliged, Lordship.
A copy of an objection has been served upon me today morning at 10:30. So I'll file a very short objection by Monday, and your Lordships may kindly have this matter on Tuesday, Millets.
But Mr. Venkatesh, is he submitted as infructuous?
No, Millets, what has happened is the question of jurisdiction of the Commission is under challenge before your Lordships in these proceedings. Now, there's a consequential order that has been passed. Now, if my Lords subsequently find, my Lords, that the jurisdiction itself, it is a question of quorum non judice. So, if your Lordships find that there's no jurisdiction in the first place, my Lords, everything else will go automatically. Merely because there's a consequential order that it cannot make this matter infructuous, because the jurisdiction of the Commission, my Lords, vis-a-vis the Electricity Act is under challenge.
But may I just respectfully submit one issue? But I leave it to my Lords to take a view, my Lords, whether this matter should be argued at length or not. But this order, which is under challenge in the present writ petition, is an order recalling the earlier tariff order. In this particular order, there is no rights which have been violated of the petitioner. There is no adjudication except to recall what had happened in the past. Okay. Now, my Lords, after a public hearing where they participated, the Commission has passed a complete tariff order governing the field. Now, if at all there is a grievance of any party, either, my Lords, the DISCOM or the industry body, they have rights and remedies available, including an argument on jurisdiction, which they can take by challenging the order which has been passed by the Commission now.
Has a new tariff been brought on record?
They filed something, the entire order is not brought on record. I'll file an affidavit bringing it on record.
24th of October, my lords. I think
that is after this writ petition is instituted before this honorable court.
Yes, yes. State has filed an affidavit, my lords, where they have referred to the order, that 24th October. I can also place it on record if your lordships may so desire.
Okay, we'll have it on Monday.
Tuesday, my lords. By Monday, I'll file my objection, so you, my lords, may have it on Tuesday.
May please, Lordship. If the matter can come up on Wednesday, Lordship, the Learned Advocate General will be here present.
Okay, Wednesday, we'll dispose of that day, yes.
My lords, my lords will fix it for admission hearing on that day, my lords.
Yes, as the counter affidavit on behalf of 105 has just been filed today itself, Mr. K. Paul, please, will have to file a small objection, reply to the same, rejoinder to the same. This matter on Wednesday.
My lords, also bringing on record the tariff order that has now been passed in October.
Let them do it if they don't do it.
We'll file a copy, we'll provide a copy. Ungraded.
Daily list, item number 1.
This matter has come for the second time in motion, my lord. We have already received instruction. We will file our affidavit, my lord.
What instruction you received?
My lord, instruction is that, my lord, this new district, my lord, Southwest Khasi Hills, my lord, this was created in the year 2012, and till 2019, the administrative and financial powers, my lord, it was exercised by the Southwest Khasi Hills district. So, therefore, her transfer order was issued during that time, 2017.
We'll file
So
affidavit.
we'll file
The Central Court please has allowed further 2 weeks time for affidavit listed after and so and so.
Obliged.
Why it come for motion then?
It should not have come.
Bakla.
Obliged.
Item number 2.
Balbinder Singh.
May
Yes,
please the
Mr.
Lordship.
Dr. Mojika.
My lord, here my instruction is, my lord, the dispute that they're raising, this is the Balwinder Singh case, my lord.
Lordship, they were supposed to file an affidavit which has not been filed yet.
I'm submitting on that.
Yes.
My lord, here public premises order has been passed, my lord, by the defense state officer. Now they are raising the challenge that this is not a defense land, this falls outside the defense land, my lord. My lord, my instructions will be lordship, because there are other matters pending before the appellate court also, my lord, around 10 cases. My lord, and similar pleas have been raised in those matters also, my lord. So, my lord, what I was praying, my lord, if lordships can direct a survey by director to land survey, my lord, this is resolve the problem for once and all.
Direct the matters not before this court, other matters, 10 matters.
My lord, here what happened, my lord, if lordship directs for survey number 26, my lord, which is the survey number 26.
Lordship, we have serious objection to this. Let my learned friend file an affidavit.
So you mean to say part of the shop is in
My lord,
land, part of the property is in defense land?
My lord, our case is, my lord, because
establishments, the entire establishments on defense land.
But as per our record, my lord, the maps which we have, my lord, the defense authorities, the area is in defense land, my lord.
Then how do you allow them to set up that establishment for how many years now? 50 years has been going on?
It's over a period of time, my lord, because maybe from British era, my lord, all these things are happening.
Then?
So my prayer, my lord, is just to settle the matter once and for all times to come.
By survey, that means what is it open to them to obtain a lease from a cantonment to occupy that place as other leases have been given?
Well, at least to determine, my lord, whether this land is defense land or not. If it is a defense land, they are liable to survey.
Who will conduct the survey?
By a director to land survey in presence of all the stakeholders.
You file affidavit first then, yes. Dr. N. Mojika, Leonard DSGI, for the response 1 and 2, has submitted that other similarly situated matters are pending consideration before the PP Court, Public Premises Court, and praised that perhaps a survey may be ordered to settle the issue once and for all. So be directed to file an affidavit in this regard.
I'll file an application.
Lordship, the interim order may kindly be extended.
After 2 weeks, yes, interim order shall continue until the next date.
Right.
Obliged.
Item number 3.
Balwinder Bar is an institution for many people of Shillong. Just like that.
Respondent number 3 and 4 have filed their affidavit in opposition, Lordship. I am praying for 1 week's time, Lordship, to file our rejoinder to that.
What about number 1 and 2?
They have already filed, my lord.
Mr. Chanda, please allow 2 weeks time to file rejoinder to the affidavit 5 verse 1, 3 and 4. Prayer allowed is after 2 weeks, yes.
Item number 4.
This matter today it was fixed for examination of witness, Lordship. We have filed an adjournment, Lordship. There is some personal difficulty on the part of the witness. Lordship, I am praying.
No, Dixon.
One thing is still interested.
Lordship, he is interested, Lordship. There was some serious personal difficulty, Lordship, today on his part. That's why, Lordship, we had to seek adjournment.
How many witnesses you have? 3?
Lordship, no, all total 6, Lordship. 6 witnesses.
They can be finished in one day.
Once the petitioner is finished, I
You
think
can
others
examine
can be
6
done.
in one day.
Not possible,
2
Your
days
Lordship.
maybe.
Not possible, Your Lordship.
Because then it's 2 days, we have to look for 2 clear days. That's the only thing.
And it should be in the second half only, Your Lordship.
Of course, second half. Who? How many you filed for
Deposition
one?
of only Lordship, election petitioner has been filed, Lordship. If Lordship allows, then we can file the deposition of others.
Your Lordship.
You filed the position then?
Lordship.
Yes. An adjourned application has been filed on behalf of the election petitioner seeking some accommodation due to personal engagements stuff. Like paragraph, Mr. Alam Sangmal, the counsel for the
Respondent number 1
has also apprised the court that evidence on affidavit has been filed only on behalf of the one of the witnesses. Accordingly, this is matter for when will record. Now the year's getting over. Then he'll be busy with Christmas. He won't be able to come also.
After vacation, Your Lordship. After vacation, after 3 weeks.
After vacation?
After 3 weeks. After 3 weeks.
After 3 weeks,
see, the thing is that fixing a date, the position this court expects that, on that date where it's fixed, at least, the deposition recorded. Otherwise, it's just a waste of judicial time. If it goes on, then by next year 25 come, then they say we don't want to pursue it anymore. It happened to all election cases here. Hardly any case is pursued with, with the real intention to see an end. We'll fix the dates then. Yes, Mr. Chanda
Not in
submits
this-
that the evidence will be filed
In this month, Your
for the next
Lordship.
date.
Not in this month. Next.
That'll be difficult. Next month also we have many. We'll fix dates. I'll consult the court masters.
Yeah, okay.
Item number 5.
Highly obliged, Your Lordship.
But it'll be 1 week after vacation.
Yeah, okay.
Yes.
Please, Your Lordship.
Kindly have the last order.
Yes. Yes, one instruction to receive.
Lordship, just received instructions, Lordship, on Monday. Lordship, the department is looking into the vacancies in the department with regards to the post, Lordship, and they have proposed to the personnel department for advertisement of the post, Lordship. If I can bring it right an affidavit, or if Lordship can.
Even if it's a contempt matter, otherwise, who's the contemptor? Mr. Ferric Roy Karkumar. He's in charge of which department?
Lordship of Sericulture and
Textile department.
We don't want him here. We don't want him to come here, standing in the court.
Lordship. Lordship, considering Lordship's order, we have to look into the.
Mr. H. Karanlang today submits that he has fresh instructions showing that the department is examining the vacancy position. He prays aloud to bring the same on record affidavit list after 1 week.
Lordship. Highly obliged.
Item number 6.
This matter, my instruction is that it is under consideration, my lord. If little bit of time is given, my lord, so 6 or 8 weeks time, my lord, we will resolve.
It's about a family pension.
Family pension, my lord.
Mr. Dr. Mazika, there's not after 2 weeks as they're trying to resolve
I'm
the
praying
matter.
for 6 to 8 weeks time, my lord.
Huh?
6 to 8 weeks.
6 to 8 weeks? You have no objection?
To finally resolve the matter.
Yes, Mr. Dr. Mazika prays that he be allowed, the respondent be allowed 6 to 8 weeks to resolve the matter as it concerns family pension. The same was objected to by MS Kharshi, and considered of 8 weeks time is allowed. Yes, to respond.
7.
Thereafter.
Please, Your Lordship. Your Lordship, I've already sent the affidavit for signatures. I'll be giving her a copy today, Your Lordship.
Signature supposed to be signed before whom?
Your Lordship, because the officer concerned is having election duty, Your Lordship is unable to
actually, affidavit is signed before whom? When a person comes to swear, the deponent,
Yes,
where
Your
is he signed it?
It'll get notarized there, Your Lordship.
No, is there oath commissioner there in the department?
No, Your Lordship.
Then
We get
you
it
send for
notarized.
signing means you send it and it's notarized by them, or it's notarized, or you do it for your
Depends, Your
commissioner
Lordship.
here.
They can get it notarized there or here.
See, the thing is that swearing an affidavit, sending for signature for vetting is one thing,
Yes,
and swearing affidavit is a totally different thing.
Yes,
So affidavit means swear before notary or before the oath commissioner. You send for signature, and that means
For
you
signature
sign
of
it at
the
home.
concerned officer, Your Lordship, the district school.
Then where does he swear it? Before notary?
Yes, Your
He
Lordship.
goes himself and does it before the notary.
Most of them.
You
do.
sure about that?
Yes, Your Lordship.
And we'll examine the records.
Yes, Your Lordship.
We just give you 2 weeks further time, but you file it, yes, 2 weeks further plate. Swearing means swearing before the oath commissioner, before the notary.
Yes.
Yes.
Obliged, Your Lordship.
Your Lordship, we have received the affidavit filed by the respondent number 4 today morning, Lordship. I'm praying for a week's time, Lordship.
By whom? Respondent number 4 is?
Is the L1, Lordship.
Successful with the
You've already started the work.
So it's completed well.
Then?
So let us file our rejoinder, Lordship, because there are serious
Then
discrepancies,
if
Lordship,
see,
in the order
Mr.
of
Chanda,
tender, Lordship.
if the work is completed, you only have to sue for civil damages. There's no question of you getting any relief from writ court. You consider that. Mr. Chanda prays, submits that as the affidavit has been, he prays he be allowed to
1 week's time, Lordship.
on the affidavit filed by the respondent number 4, just after 2 weeks, yes.
Nine.
It's become useless, the writ.
Item number 9.
Affidavits are awaited, Lordship.
What's the matter about?
It's regarding compensation for land, Lordship.
Well, I have not been able to file affidavit. Well, I'm praying for some more time. 8 and 10 minutes.
1 to 7?
1 to 7.
And you 4? 1 to 7.
I'm 8 and 10 minutes.
8 and 10, okay. The counsel for the respondents pray for allowed further 2 weeks and file affidavit. This thereafter and so on.
Obliged.
10. Item 10.
Counsel for all the respondents. No?
I'm praying for respondents 4 members.
I'm sure. Yes. Yes?
I'm for 4 members. Pray for some more time. Even the state is not filed affidavit.
Here for Mr. 1 and 2. Number 3 is whom?
My Lords, we have filed an affidavit bringing on record the service being effected on respondent number 3.
And after indicating service on respondent number 3 has been filed. As such, all the respondents are represented. Dr. N. Mr. A. Karunalang, on behalf of 1 and 2, and Mr. Dr. M. Mozika, for pray for allowed for the 2 weeks time will affidavits. This is thereafter.
Obliged, Lordship.
Thereafter and so on, so for affidavits and for appearance of the respondent number 3.
Highly obliged, Lordship.
11.
Hamid, this is your Lordship. Lordship, we are praying for some more time, Your Lordship. A few weeks' time, can you be allowed?
Number 11 took steps.
Yes, Your Lordship.
Served.
Your Lordship, I may be allowed to obtain service report.
Not received by yes. Yes, sir.
Lordship, 3 weeks' time, can you be allowed, Your Lordship?
Mr. Andy Shulan AG is also for response 1 to 5 and 8.
1 to 5.
What about? You're filing? Oh, and EB pass out number 9. What about number 10, Deb not? Number 9, Abengata, pray for allowed 2 weeks for the time file affidavit. None appears on behalf of respondent number 10 stop. It's also noted that service that the service report on respondent number 11 is yet to be received. There's up to 2 weeks.
Apply
for the orders.
12.
For 12, I'm praying for some more time. 12, 13, and 14.
Yes. How much time?
3 weeks' time. 3 weeks' time.
As paid for the 3 weeks time allowed to the
12, 13, 14.
Yes?
12, 13, 14. 3 matters.
15.
Yes, please, Lordship. Lordship, this matter, Lordship, they haven't filed their affidavit, Lordship.
Who has filed?
They have not filed, Lordship. This state respondent.
Mr. Khan.
Lordship, this is that matter, Lordship, where my name was removed from the master roll list, Lordship, by referring to one rule which is not applicable according to me, Lordship.
It's a post-file affidavit. Where's the yes.
Lordship, in the last occasion, Lordship has issued notice and they have accepted notice, Lordship, but there was no observation, no directions asking them to file their affidavit.
Whatever it is, what they once they accept notice is expected, they come with instructions.
Lordship.
No instructions.
2 weeks time, Lordship.
Mr. A.R. Khan, we have the response place forms allowed for the to obtain instructions of the file affidavit. Just after 2 weeks.
DB applies.
16.
Hearing something.
Similar prayer in this matter, Lordship. 2 weeks, sir.
2 weeks for the time allowed respondents to obtain instructions and to file affidavit.
17.
Lordship, in this matter, we need some more time, Lordship. 3 weeks, can you be allowed?
You corrected the typographical errors? Yes. Was it about pension?
Yes, Lordship.
Regularization.
2 weeks for the time as paid.
Apply.
18.
So in this matter, we are waiting the instructions. We are praying for time. 3 weeks.
This was moved 22nd of October for the 2 weeks time as paid allowed for instructions and affidavits.
Similarly with item 19.
Prayer?
18 and 19 is similar.
Hearing. Supplementary list item 15.
Yes, why did we ask for it again today?
Actually, yesterday we were engaged in the division bench. Yesterday we were engaged in the division bench, we were not part of the hearing.
Yeah. See, they have challenged that the authority that issued the impugn order is not a competent authority, should have been district council.
Lordship.
Should have been district council who should have given notice.
Lordship.
Whether and how many meters are you fixed from the
It's 50 meters, as per the notification that we had issued. Now there was a order passed by the NGT, and now after the order, Lordship, There was a meeting with all the stakeholders. It was held by the
One
state
second.
government.
Let me note. Done. Where were we yesterday?
Yesterday, my lord, there was an objection from the state to identify the jurisdiction of
Suggestion, that the first number one to ascertain where the property is located and whether the Town and Country Planning Act actually extends. That would help us establish who is the authority to issue the permission for the construction. And number two, keeping in mind the new rules, the guidelines that have been made by the state government of 2023, we have to ascertain where this property is located, how far is it from the water body. Because my learned friend had indicated that the inspection was conducted in his absence.
The petitioner's absence. That was his case, Lord.
So you want this matter to go back there?
No, while this matter is pending here, within the next 2 weeks, all the parties can be present for an inspection. We'll submit a remote for lordships.
Because you're staying in the house now?
Yes, my lord. Residing there only.
You said there's a motorable road below your house also?
Kacha. Yeah, 6 feet path.
Motorable road?
Motorable road.
You're using that road to approach your house?
There's also done staircase also, my lord.
No, but you're using that road to go to your house also?
That I have to take instruction. Maybe, my lord. Probably.
You agree with that suggestion?
Lordship.
Do you have personnel there? Or they all have salary and they can't go anywhere?
You can instruct them, Lordship. You can instruct them. Lordship, this, in fact, this land falls under the Caroline Colony, Lordship, which is in town itself.
Caroline Colony?
Caroline Colony. As per the landholding certificate, Lordship, at page 12, page 18.
Page?
At page 18 of the writ petition, Lordship.
Is that part of Jowai town?
Jowai town, Lordship.
Page?
Page 18.
Is that correct, Mr. Shongwan?
No, my lord. As per my instruction, it's not correct.
Banshatingit, yeah?
Banshatingit, Lordship.
Banshatingit.
Village Caroline Colony.
Banshatingit means the village or locality?
This is the location, Lordship. Schedule of the land is building site, Lordship. Location, Banshatingit. Village is Caroline Colony. This is in Jowai, Lordship. It's in the town itself.
If I may.
Let me just clarify, my lord.
Your lordship recollect this location is exactly situated in that before reaching Joy there is one PSE office where they stock this pipeline in the River Mantudu, and opposite that stock pipeline of the PSE there's the location of the house, whereas this Caroline Colony is in Latlobo. It's a part of Latlobo.
That's what, no, but it's not the, one thing, Mr. Nongpur, suppose a house has been constructed before any of these, directives came into play regarding 50 meters, prescriptions. Or now, do you have any mechanism to condone that or compound these infractions?
Sure, there's an act by the district council.
No, but can you compound it? Because his cases are, look, he is not a willful violator, correct? He has built a house there from whatever permissions to be got from anyway, he's got that. That's what he says. He got landholding certificate showing his land. He building from Rishnong, there's no other authority, so he started building. And all these are subsequent. After he moved in, all these subsequent events have happened, whereby he's been served with notice, there's building 50 meters. So is there any provision for compounding?
Lordship, so far as the landholding certificate is concerned, Lordship, this particular place is a building site, Lordship. Now, as per the 1974 Act, the Village Town and Administration Act 1974, any erection of any construction of building, permission has to be sought from the competent authority. Now, so
Which
far as
district
this case,
council?
from the district council. Now, so far in this case, we had only issued them landholding certificate. Now, thereafter, what happened? They are never intimated to us, Lordship. But so far as the act is concerned, they have to seek a prior approval from the competent authority.
It's a very small part of land also.
Not
It's only 2,400. It's meters.
Square meters, Lordship.
Not square meters.
Oh, then it's quite big then. 20
No,
as
no,
far
no,
as
madam.
square feet.
Square meters, Lordship.
It's more than 20,000 square feet. Square meters.
Square meters.
Even the map sold Caroline Colony.
Lordship. Lordship, if this honorable court is of the proposition that an inspection is required, perhaps we can.
Your Lordship, come to page 16 of my red petition. This is the original sale deed. It is area is 2,600 square feet long. 2,600 square feet. That is the
Then-
original. I think
then-
there's a
then-
misprint
then
while
landholding given you
more
10 times
than what I deserve.
So you're very lucky. How is it possible then? Landholding says, see,
Yes, my lord.
that map says the area is
The original sale
245.
deed, page 16.
Oh no, 245. Not 200.
Yes, yes,
not
245 square meters.
Yes.
It's just 2,600 square feet.
Yes. See, I don't understand. Village call Panchat and then located Caroline Colony.
No, location is
It has to be a colony, or it can't be a village can't be part of a colony.
no, location in Banshathingit, Lordship, and the village is Caroline Colony.
See the map.
As per the landholding certificate, Lordship. The landholding certificate will clarify, Lordship.
Landholder says the standard form. Then he'll have to go for NGT. That's the problem.
Lordship, because
If we are depending
notification
on
also
orders of
stems from the
NGT,
NGT order.
No,
Lordship. Even the notification that we had issued, it stems from the NGT order.
where the notification you issued?
Lordship, it's
In the
we
affidavit?
close that in the affidavit, Lordship. Page 5.
Excuse me.
Page 5, Lordship.
Yes.
Point number 1, number 2, Lordship. Point 1, Lordship. No construction of any structure, whether permanent or temporary, for residential or commercial or industrial or any purpose, shall be undertaken within 50 meters of the bank of any river. Further, no agricultural land within the said distance shall be converted to a non-agricultural land. This notification is dated 10 November 2020, Lordship.
And notice given to the petitioner?
The notice, the show cause notice was issued on 5/7/2022, Lordship. Much later than the notification.
And he occupied a house when?
In June 2022, now.
He constructed his house
August 2020.
after the notification.
If I may submit, my lord.
1 second. Yes.
Basically, Lordship, the stand of the District Council is of twofold, Lordship. One, the notification has been issued whereby restrictions has been issued whereby no construction should be within the 50 meters, and that notification has been issued pursuant to the order passed by the NGT, Honorable NGT. Now, second ground is, Lordship,
Yes.
when we had issued them land holding certificate, which is the land which is for the purpose of building site, it is incumbent upon the petitioner to seek approval from the District Council or to even inform the District Council that we have constructed this house under the town
So your
planning
stand is
act.
no permission.
No permission. No permission sought from under
From
the
the
Act
DCA.
1974. Yes. And third, the impugn order is a valid order, Lordship, because
It's not
that
issued
falls
by
under
you.
falls under the purview of the district, by the state government, Lordship, state administration.
See, that's the only challenge that's made.
And fourth ground, Lordship, the notification which the district council has issued whereby restrictions have been set out, that has not been challenged by the petitioner.
No, because of challenge, you have not, from your part, you have not issued him any notice.
We have not issued them notice.
Yes. And that law,
We're relying
that
on this
land
notification.
falls solely within your jurisdiction.
Lordship.
That land falls solely within your jurisdiction. It's not part of the Joy Municipal Board.
It doesn't fall under the municipal board.
Doesn't fall under municipal board, correct? But Caroline Colony will fall under municipal board. Yes or no?
Maybe Lordship, I have to clarify that aspect.
Mr. Suna is more well versed. Caroline Colony is in municipal board. It happens all out here, all multi agencies. Let us see your petition. Now this come to page 23 and Lecture 5, the petition.
Hold on.
Inspection you're saying, Mr. Sen, is that inspections conducted on 35/2022 as per the paragraph 4
Of my affidavit.
of the writ petition.
Of the writ petition.
1, 2, 3, 4.
In the show cause notice itself.
Lordship. But just before that, if I may just take Lordships to my affidavit, just to indicate the minutes of the meeting. Can you see page 13? This is the typed copy.
Page
13.
The respondents.
So the NGT order is 27th of February 2017, and this meeting was held in the office chambers of the DC on 31st of May 2017. If your Lordships have that page 13.
Yes.
So may I just read, Miller, from para 1 onwards. Prohibitory orders under section 144 CRPC has already been promulgated by the district magistrate prohibiting dumping of soil, garbage, washing of clothes, vehicles of all types, setting up of service centers for washing and service of cars of all types, disposal of sewage, disposal of direct flow of waste, feces, etc. to Vituru River. However, fresh orders under 144 CRPC shall be promulgated when the present order lapses. All headmen secretary of different localities assure the chairman and members to cooperate and coordinate with the district administration and village and Juwai Municipal Board to prohibit dumping of soil and garbage all around the corners of Juwai town. The headman shall conduct a survey of households of their respective localities without toilets and to issue directions to such households in their respective localities without toilets and to issue directions to such households. I'll just come to I'll come to paragraph 4. With regard to construction of houses taking place along the banks of River Mintudu, as indicated by the petitioner,
Yes.
it is resolved that the matter may be referred to the GHADC, which is the competent authority. The GHADC shall state clearly the parameters, criteria, rules, etc. related to the distance allowed for construction of residential houses, etc. within the distance of 500 meters from the edge of the Mintudu River, and to verify and issue necessary orders on steps to be taken with regard to any ongoing construction works in the area. The Secretary GHADC shall henceforth examine the suggestions in petition at point number 4 and take steps not to convert paddy field patta lands into residential property for those lands located within 1 kilometer from the edge of Mintudu River, and not grant any building permission, etc. to any individual or party within a distance of 500 meters from the edge of the Mintudu River. Proper procedural steps are to follow in such cases accordingly, after taking into consideration the existing rules and laws, if any, adopted followed by the JCDC. Accordingly, all headmen and secretaries of all localities of Joai town are requested not to issue any NOC for any fresh construction in those lands located within the edge of River Mintudu until such applications fulfill the criteria, rules, conditions framed by the competent authority, which in this case is the GHADC and the Urban Affairs Department wherever applicable. So this is in 2017 with the participation of the traditional bodies. Despite that, what they only have is an NOC, not really a permission.
No, what his basic case is that show cause issued by Deputy Commissioner when it's not under the jurisdiction of the Joint Municipal Board under the Deputy. That's all.
Lordship.
So that and as per your meeting will show that that the authority, the competent authority will be District Council, and his contention is that from District Council they have no problems.
Lordship. For that one, if your Lordship will see the NGT order, the NGT order indicates the directions were issued to the state. So they had to formulate a policy and give an action taken report before the NGT itself.
There's 18/7/22.
27/2/2017.
Yes.
So kindly see page number 3.
So that is why they have really, give what do you call it, delegated authority to the.
We've delegated it only for the purpose of determining the distance. That is the policy to be taken by the GHCC because they are the ones
So
issuing.
you see that what you read again just now.
Hello.
See, read 5 and 6. Okay,
Of my,
5 of that you read just now, page 13. 6, according to headmen secretaries, not to issue an NOC any fresh construction when the edge of until such fulfill rules conditions also. In this case, RGHDC and Urban Affairs, wherever applicable.
So Urban Affairs only wherever it is applicable. Otherwise, it will be GHDC.
Exactly. So if this condition is there, that means he obtained an NOC from the village head.
So they are not permitted to do so. What it's saying is that your Lordship will see headmen are requested not to issue any NOC, and this is in 2017 with their participation.
Exactly, but then NOC, how is he to be held liable then? He got an NOC. It was the duty of the headman, if as per his meeting, that means that the GHDC should have, whatever show cause should have come from them, if any.
Lordship.
Correct.
So, which is why I was just referring to, I understand that the state has delegated that responsibility only for the purpose of determining the distance. As far as implementing the action on ground, it was for the state, the district magistrate.
Where does it say?
It doesn't say that, my lord. I think that was the understanding between them. So if your Lordships will see the order of the NGT, 27/2/2017.
Yes.
So the liability to ensure that nothing happens insofar as the river is concerned is entirely on the state. Page 3 of that order, the last paragraph. Considering the seriousness of the matter, we deem it essential to direct the Chief Secretary to issue directions upon the appropriate departments to verify and submit a report on the allegation contained in the OA. We also direct the state PCB to take samples of the water at different points from upstream of the river from Joai and downstream also after Joai municipal limits. The samples shall be collected from at least 5 points. Let the samples be analyzed on various parameters, that is coliform count and so on, and a report be filed without fail on or before the next date. In the meanwhile, we direct the state respondents to ensure that no illegal sand mining or other such activities are permitted along the riverbank. So in their understanding, whatever would be decided as far as a policy decision is concerned, as far as JHDC is concerned, enforcement would lie with the state. I think that was the basic understanding.
Now, with regard to other construction, what do you do in July, in the mid-through? Can you show some samples of whether it meets the requirements as given in the meeting and the orders of NGT by the district council itself?
I'll have to take instructions whether any action has been taken by the district council. But so far as the NGT order is concerned, as my learned senior has submitted, Lordship, that fall under the purview of the district administration to ensure that there's no activities carried out beyond near the river, Mintadu River, Lordship.
See, this is a very general order. Considering the seriousness of the matter, we need to direct the Chief Secretary to issue action upon appropriate departments. We don't have appropriate departments in this case. The District Council is an autonomous entity. So this order, you can't take it at face value to say that it has vested power in the government itself. Because in all other things, the District Council has that's the only thing, how to reconcile this show cause, whether it is passed by competent authority. That's all. But thing is that will save you is, there was an inspection. So what does the inspection say, the 3522?
They have never produced a report, Malon.
You never annexed that report also. See in your show cause, see in this para 4 of your, that 5th July 2022. And it's based on this report that they found his house to be in. See? Then we don't need a survey, you know, because if the inspection is already done.
No, his grievance was that he was not present. And he claims it is not within so and so distance, it's about 30 meters.
See, there's going to coordinates here also. How big is the house?
No, it's a small house, Malon. Because it's in a slope, it's a 2-story only, but not that big also.
So as Lordships was suggesting, whether there's any possibility of condoning, what I would suggest, the departments can meet together, JHDC as well as the state, and see whether it really poses any sort of a threat or a risk to the river. If they feel it doesn't, they can take a call and report back to this court.
No, if see, the law is the law, and whatever policy decision has been taken, that has to be implemented. We're just saying whether what does the spot inspection say, whether the other have similar notices been issued to other buildings.
Yes, we have such an RF.
Yes, in the course of hearing,
If I may submit, my lord,
yes.
One more point of law. Now, I'm on the point of law, which law have I violated, my lord? Now here, my lord, I am only liable to be penalized for any violation of any law which is enforced at the time of the commission of, that is a settled law, which my lord also is very much aware. Now what happened here? The NGT order which has been passed in 2017, it is not a direction in rem, my lord, it is a direction to the state respondents who were present there before the Honorable NGT. Now it is a decision which has been given to them to take steps in order to formulate laws and policies so as to prevent the water body, my lord. What happened here? In August 2020, I started construction of the house. Belatedly, the notification of a district council specifying the distance from 50 meters from the water body came after I have started construction of the house. No one has come forward to intervene in the midst, hence I cannot be termed a violation of the
No, not
order.
saying you're violating, but see, if
And again, my lord, if I may finish,
Yes.
the order of the government also formulating that rule, specifying the distance and all, it came only in the year of 2022. Belatedly, both the orders, my lord, they came after when I have started all the construction. So the law was never already in place when I started the construction. The question of violation, my lord, which law have I violated, that also has to be replied by the
that will be in the final hearing.
Yes.
Right now, we just have to get the facts straight. That's the only thing. That they've done inspection and all. In the course of hearing, it is seen that in the show cause notice dated 5/7/2022, mention is made of a joint spot inspection and measurement of structures along the banks of River Minturu on 35/2022, conducted by the district authorities together with the Jaintia Hills Storm District Council and Forest Department. Forest Department, by the district authorities together with the GHADC, Forest Department, District Urban Planner, and the Joy Municipal Board. A copy of the said spot inspection has not been produced before the court, which will go as before the court. It is deemed necessary that the said report be placed, as it's on the basis of this report that the show cause notice was issued to the petitioner. The other aspects regarding as to whether Deputy Commissioner stroke District Magistrate's competent authority to issue the show cause notice will be determined at a later stage. This matter after you can put 2 weeks. Just please let's see on what basis it is after 2 weeks for further hearing and for production of the said survey inspection report and for further hearing.
Obliged, Madam.
Daily list 24.
Yes, Mr. Deb.
Your Lordship, we are seeking Your Lordship's indulgence to direct the respondents to consider our appointment on humanitarian grounds.
Humanitarian grounds, not compassionate grounds.
On compassionate or humanitarian grounds, Lordship. The brief facts was that, Lordship, the petitioner's husband was appointed in the police department in 2008. He was in service, Lordship. However, in 2013, he unfortunately passed away. The department, Lordship, considered his demise to be on duty, and thereafter, Lordship, immediately after his death, in 2014 itself, the application for compassionate appointment or on humanitarian grounds was submitted to the department. Lordship, the application was in process from 2014 till 2018.
Let's see the application.
Lordship, the application is at page 34A, Lordship, type copy. A is the typed copy, Lordship. He was originally posted in Meghalaya Police, Lordship, subsequently transferred to Delhi and then in that time, Lordship, during his paid leave, he met with a train accident in 2013 and unfortunately passed away, Lordship. At that point of time, along with the petitioner, there were 3 minor children. So I had submitted, Lordship, the application in 2014. Thereafter, Lordship, kindly have page 35. This was the first letter issued to be, Lordship, forwarding my application.
No, but the compassionate scheme point is gone. There's no
that
more.
is the only.
None exists any longer. Yes.
Lordship, so I'm praying, Lordship, if they can take a compassionate view on the matter, Lordship.
Have you got a family pension?
Lordship, no, because only 5 years of service was there. Now there are 3 children, Lordship. I have not in a position. I am running door to door to make ends meet.
She is getting pension limits. It is in their application. It's in their petition.
The pension is about 4,000. I have mentioned in the
pension is about 11,000 per month. Paragraph 4.
Yes, so
I'm praying for a humanitarian consideration of my Lordship, because they have rejected one line that a scheme is abolished.
Where? In abolish you can't. Then there'll be hundreds and thousands of petitions. Yes. Where's the rejection letter?
Lordship, rejection, Lordship, will kindly have at page 47. Page 47, annexure 10, is a letter, Lordship, copy has been given to me that.
See, where are you saying, MS Shyam, that she's getting pension? Where?
I have mentioned
in
in
their
my
petition, page 16.
itself.
The petition, page 16, paragraph 4.
Yes, it's not
Further,
that
she
he-
had
it's
received
not
an
that he
amount of
just-
11,000.
Where's that?
Paragraph 4, my lords.
Okay.
She has received an amount of rupees 11,000
This
per
is
month.
not the pension as pensionary benefit, but this is not the monthly pension, lordship, because 5 years of service only was there. It's like a
You mean to say she's got 11,000, nothing else?
lordship.
No family pension. She won't be even entitled to pension.
because
5
the
years.
5 from 8 to
What about
13.
ex-gratia payment?
No, lordship, no ex gratia or compensation. At least some, lordship, because I had
Because he died on duty.
died on duty, lordship, and
Deemed to be, my lords, because
Whatever it is, he would have gone to Delhi if he was not sent on duty then.
that letter
Yes,
is
board
there.
will take that view also.
That letter
because
is there.
like, he would have gone to Delhi. He would have been on a train if he was not good here, didn't go on duty.
my lords, he had taken leave on that very day. He was on a leave. He had taken leave.
That issue has been clarified by the department in
It is in
2016
there.
itself.
Where?
That page 35, that
And it's-
since the deceased died while on leave in duty, it may be
Annexure
considered that he
3.
died on duty.
And affidavit,
No, in my writ petition itself, lordship, page 35.
page 33.
35, annexure number 3, lordship.
Annexure 3, my lords. He had taken a leave of of 15 casual days and another additional 10 days. He had boarded the train.
We consider he died on duty.
Yes, since
Yes,
yes,
my lords.
it is therefore
So
requested that a
that's-
petition will be
that is
kindly considered.
Not in controversy anymore.
Yes. So this was the first forwarding in 2016 from the commandant to the AIG, and thereafter, lordship, it was under process, and finally in the year 2018 I got lordship, this financial certificate from the magistrate as per the
You sure are getting pension at all?
no pension, lordship. Lordship will kindly have the certificate at page 44. It's issued by the DC office, lordship. The financial hardship certificate, page 44.
Even then, Mr. Deb. He died when?
2013, lordship.
2013, my lords. The day he boarded the train, 19th of April, 2013.
Now the children are 17, 19, 21.
Lordship, yes. At that point of time, they were very young, lordship. 7 to 8 years.
7 years ago.
Yes.
They're all adults now, right?
Now.
All of them, yes.
Sorry, Mr. Deb.
Lordship,
Just find out where she's getting any type of. Just find out whether she's getting any type of family pension. Just find out. Then we'll see whether we can. Yes, in the course of hearing, it has been submitted by MS Sham that the writ petitioner is availing of a family pension, which is not refuted by Mr. S. Deb, the counsel petitioner, who submits that only 11,000 has been received as term benefits of the writ petitioner. We need to get instructions. Learn here to obtain instructions as to whether any financial assistance had been extended to the writ petitioner, the demise of our dear husband. Yes, which was counsel on duty.
if not, then maybe they can pay one ex gratia of that, the 2.5 lakhs or something.
Whatever, there's some
Let them
scheme.
lodge,
The
yes.
police have.
Lordship.
Item
Just
30.
find out, even the policemen, they have their own scheme also.
Yes, my lords.
Yes.
Right, my
Obliged.
lords.
30.
Yes. Where's Mr. Marpan?
Your Lordship, counsel for the petitioner was under the impression that the matter was being adjourned today, so.
What do you
she
mean under
gone-
impression?
Your Lordship, she informed me that she was told by the other respondents that they would seek for time.
Who's that counsel? I saw.
Ms. Nombre, Your Lordship.
Let's ask away. Yes, at the request of the parties, list as matter of 2 weeks.
Obliged, Your Lordship.
I like that, under the impression. Then I should use it as a lawyer also then. Under the impression that the matter has been adjourned.
Your Lordship, that's what she informed me.
Now lawyers are much smarter than what we were before.
I bet you.